Hello, everybody. Welcome back at our session panel. Our session panel will deal with the question, public interest analysis in Africa, critical cases and critical concepts. I'm very happy to introduce you to a very esteemed panel of practitioners across Africa. The first is Ahmore Burger-Smidt. Ahmore is the head of regulatory at Werksmans Attorneys and former designated deputy commissioner at the SA Competition Commission. We have Calistar Dzenga. Calistar is the head of the Mergers and Acquisitions Division, or the Mergers Examination Division of the Zimbabwe Competition and Tariff Commission. We have Nomathemba Dladla, the Director of Mergers and Monopolies at the Botswana Competition and Consumer Authority. We have Raphael Mburu, the Manager of Mergers and Acquisitions at the Competition Authority of Kenya. We have Stephen Velthuysen. Stephen is an executive responsible for legal, secretarial and human resources at Clover S.A. And Wiri Gumbie, Principal Analyst, Mergers and Acquisitions at the SA Competition Commission. Thank you very much for joining us for this discussion today. We are truly humbled by your presence, panelists. Today we are going to consider competition authorities' efforts in Southern Africa in dealing with macroeconomic dilemmas, including remedies that try to remedy macroeconomic difficulties. Just for purposes of background, at Betweenity we do not only monitor developments across Africa, but we also monitor the reactions to those particular developments. And we noted something that appears to be very interesting, and that is that Northern African competition authorities appear to be much more involved and outspoken about economic or government policies that may have spillover effects elsewhere in the economy. And that doesn't necessarily pertain to competition policies, even if they are policies, for example, related to tax or other macroeconomic policies, then they are very quick to highlight those connections and the risks and the system's effects between the macro and the microeconomy. And this is in contrast to what we many times observe in South Africa, or sub-Saharan Africa. There's much less of an open participation by competition authorities of own volition about connections between different parts of the economy, especially between the macro and the macroeconomy. And they appear to be more silent on the long-term consequences of decisions. And what we also see is they seldom value the benefits of size. So the purpose of today's discussion is to delve a little bit into this connection between the competition authorities' microeconomic interventions and macroeconomic outcomes with reference to a couple of examples. And these are, in relation to Zimbabwe, the recent conditional approval of a bank merger that led to the withdrawal of the merger by the parties due to the conditions being too onerous, according to the media. And in Botswana, we will look at the imposition of conditions that require numerous new entrants, among others, to occupy valuable positions in the petroleum supply chain. In Kenya, we will discuss the implications of the finance bill that was not approved last year, but there was an intention to approve that last year, and just that intention resulted in a lot of what's the word? Outcry and deaths as a result of protest action. So we will consider that and whether it is something that the Kenya Competition Authority has taken into account either before or after the event for purposes of policy. In South Africa, we will ask the question regarding the so-called positive obligation on merging parties to promote ownership, and whether that is appropriate in the context of a particular High Court decision involving the mineral counsel, as well as long-standing tribunal case precedent that has been omitted from the public interest guidelines insofar as ownership is concerned. And in South Africa, we will also consider the treatment of mergers involving international companies. Thank you so much for your great involvement, all the speakers. And as I said, please feel free to jump in at any moment if you'd like to add something or even ask a question. Calistar, let's start with you and the discussion regarding the merger involving CBZ Holdings and ZB Financial Holdings Limited. In that merger, as I indicated, the Competition Commission, or let's say the CTC, came with a set of conditions, and the parties were quite anxious about that. And according to the media, there was a lot of critique, and it would be great to get your views on that matter. According to the media, the merger was abandoned by the parties because of the onerous requirements set by the Zimbabwe CTC. The chairperson of the board of CBZ disclosed to Business Times that the regulatory hurdles have jeopardized the merger. Some of the conditions do not make sense from a national or organizational perspective, and the conditions as they stand create challenges in terms of moving ahead. And from a development perspective, he said that one of the biggest challenges in Zimbabwe is the presence of 16 very small commercial banks, and at least $20 billion must be mobilized annually to meet Zimbabwe's investment needs. No single bank, according to him, or even all the banks combined, has the capacity, does not have the capacity to mobilize those resources, especially from international markets. And he also said that the merger would have created a large financial institution capable of mobilizing large amount of funding that was necessary for Zimbabwe to go forward properly from an investment perspective. So, Calistar, can you please take us through that merger? Which concerns did you identify, and what were the remedies that you proposed? And was this the first time that the Competition and Tariff Commission came with conditions that a party said, let me rather not proceed with the merger? Thanks.
Thank you very much, Odie, for the engagement. Indeed, the Commission analyzed the merger involving CBZ Holdings Limited and ZB Holdings Limited. And so the transaction was happening at a holdings level. But from our assessment, we then saw that these holding companies had various other subsidiaries that were also going to be affected by the transaction. And in our analysis, we also incorporated the recent acquisition by CBZ of First Mutual Holdings Limited, in which they had acquired a great stake. And so we considered that as being a subsidiary of CBZ Holdings Limited. So our assessment really was extensive, not only limited to the holdings level, but also to the subsidiaries of the merging parties. And so our assessment was quite thorough, and we identified serious competition concerns in that transaction in various markets, but I think those which were quite significant were the reinsurance market, because the transaction would lead to a removal of an efficient competitor, which is ZB Re Insurance Company, a subsidiary of ZB Holdings Limited, and also the transaction would also increase concentration risk of other insurance entities. So we thought that that was going to be an anti-competitive effect of that transaction. And in the banking market, we projected a shift of concentration level from an unconcentrated market to a concentrated market. And so that transaction would really enhance CBZ's market dominance. But in that respect, we also carried out consultations, and we found out that ZB Bank served the lower end of the market, while this CBZ served the upper end of the market. So these two banks served different markets, even if they did compete in the banking sector. And ZB also served the SME banks, sorry, the SME market, while this CBZ served the corporates. And so we thought that it was really important to maintain these as separate brands for the enhancement of consumer choice. Otherwise, one of the market could suffer post the acquisition. And we also identified serious competition concerns in the property development market because ZB Reinsurance had Mashonaland Holdings as its subsidiary, which is a big property development company, and CBZ Holdings Limited at CBZ Properties as its subsidiary. And this market was going to be highly concentrated post the transaction. We also identified competition concerns in the short-term insurance market. And so from our assessment, and also noting that there was this need to really, for them to capitalize and finance big projects, we then decided to approve the transaction subject to a number of conditions.
Yeah.
And one of the conditions was divestiture.
Yeah.
Divestiture of by the merged entity from Mashonaland Holdings, from ZB Re, and from Cell Insurance. And
Yeah.
also on the banking side, we did not reject that transaction. On the bank side, we just said that the merging parties should maintain separate brands. So that ZB Bank will remain existing, CBZ Bank will remain existing, and so that it would really enhance consumer choice. That so that the banks could continue saving their clients, which they were saving before the transaction. And we had several engagements with the merging parties and trying out to come out with the remedies, but unfortunately, we were then told that the parties then abandoned the merger. But from our perspective as a competition authority, we did not prohibit the merger.
Yeah.
We just approved the merger subject to them adhering to conditions which we thought were really necessary to maintain effective competition in the identified relevant markets.
Yes, yes, I see. And how did the CTC experience this withdrawal of a merger? Was it something that you expected, or was it a little bit unexpected? And was there perhaps a thought that maybe we were too strict, or were you very happy with the way in which you have done the analysis? Because it sounds like a thorough analysis.
So Odie, we did engage with the parties, trying to come up with the remedies. So normally our procedure, we are analyzing measures. If we identify any competition concern, we first flag it with the parties before we come up with the remedies. Yes. So we did engage with the parties and told them that these are the competition concerns that we are identifying in this particular markets. Can you try to come up with the remedies that could potentially remedy these competition concerns?
Yes.
And the engagement went for 6 months, and like in the normal major examination where we can have a maximum of a month in engagement. So we had 6 months, and the parties also requested for an extension of the timeline as they needed to liaise with the shareholders of the companies and try to come up with the remedies. And to us, we think that these were fair remedies because we did not outrightly prohibit the transaction, even though it would substantially lessen competition. But we understood them from an investment perspective and also from their quest of creating a giant that could compete even in the region. We then said, no, you can proceed with the transaction, but just divest from these companies so that we can also promote competition in the other markets. And so we're not sure whether they saw the condition is in some, but from our perspective, we did engage with the parties before coming up with the remedies.
Yes, I see. Yes. And Stephen, if one consider the comments by that bank boss, and you having been involved in various mergers, what types of conditions work and which ones do not work? Because the comments of that bank boss, I'm just going to refer to him like that. I don't want to refer to his name here. He said, for example, that the conditions imposed by the CTC did not take into account the organizational situation. of their banks, and also it was infeasible to conduct that at a national level. So, and based on your experience of mergers, what types of conditions work, which ones do not typically work, and what type of advice would you give to a competition authority in terms of the practical execution of a condition?
Hi, thanks, Wiri. I think if I can speak from a South African perspective, we see that the Competition Commission are getting more policy-driven. If I can put it that way, more merger-related issues are being considered now than merger-specific. So parties from the start are aware where the focus are going to shift. And we know now already there's 3 or 4 things that parties are going to look at. The traditional things that come up is your employment share schemes, your preservation conditions on employment, support for certain small, medium enterprises, and certain consumer protections.
Yes.
Ask me from what potentially worked. I would say that employee preservation conditions, definitely from a South African perspective. Nowadays, you see 5 years plus, no retrenchments, and certain conditions attached to that in terms of funding for employees, etc. And then we've also seen in some of the recent bigger mergers in South Africa, I think at Walmart and AB InBev, there was a specific drive towards compliance with procurement from specific disadvantaged suppliers and etc., which I think, and it's still ongoing, is definitely maintaining the status quo, and I think things like that work.
Right.
I think if you analyze some of the conditions that were imposed on some of these big firms, some of them international, you see emphasis a lot on ESOP, employee share owner schemes nowadays. If I can refer to, was the PepsiCo one, there was a 5% employment scheme and it was billions of rands they needed to invest. Now, for an international firm that was involved, for them it is potentially something that they can absorb. But if you look at local firms, that might not be something that they absorb. And I think what we need to see is that there is a careful balance between driving these type of transformative agendas and public interest agendas versus staying still relevant and seeing still encouraging deals that is pro-merger and merger pro-competitive. We don't want to see deals go down the withdrawal route because the investment case of the merger doesn't make sense anymore because the conditions places additional financial burden on the parties. So, having said that, I think from a competition commission perspective, what is important for the parties is we know what's coming, we know where the focus is to build your case to the commission, and then I think it is for what we want to see from them, and we do see to some extent is involvement of all the stakeholders in a merger like that. And there, it's not just the executives and the shareholders, but also the labor unions, etc., and start building this investment case together with proposed conditions. I guess what we want to see is clear specific conditions that's measurable and that's attainable and still makes business sense for that's essential for the survival of this deal. And I think then if you can get that right, then you have a clear balancing act and the commission can continue driving towards this balancing act of transformation, staying still, making investments still attractive in South Africa.
Right.
I think in a nutshell for me is more or less where the focus should be.
Yes, right. Thanks very much, Stephen. And if you say it must be measurable and it must be practical, Have you come across conditions that were just not practical, or that you felt that was imposed but didn't really move the needle?
Yeah, I've seen in some mergers they would ask for a sort of a development fund for employees, for instance.
Yes.
But there's no specifics of what this development fund must address.
Yes.
And how many employees it must address, and how is it going to be measured, and what is the success of this is going to be. So, at the end of the day, it sort of feels like you're giving the company to throw money at something just to tick a box.
Yeah.
But you don't see any measurable
results
KPI on this type of thing. So that makes it a bit blurry, and it seems to me like something that I don't see. I mean, having provided the commission with feedback on progress on some conditions, I just don't see how they actually measure these type of things, because it's you know, then it's just a tick box exercise, which I don't think is what they really want.
Yeah, that's right. Yes, thanks so much, Stephen. I'm going to move to Raphael and the deadly protests that we saw in Kenya. It was less than a year ago. Last year, on the 26th of June, 23 people reportedly died in mass protests pursuant to the Kenyan government's intention to pass tax hikes on the sale of basic products, for example, diapers and money transfers and so on. And that was a tremendous failure in policy. And after the protest, President Ruto had reportedly said that he decided not to sign the finance bill, having listened to the people of Kenya who have said loudly that they want nothing to do with this finance bill. Raphael, from your perspective, had there been any interaction between the CAK and government in the context of that bill, either before the bill was finalized and tabled, or even thereafter? And what do you think went wrong in that particular policy space?
Thank you, Odie, and appreciate for inviting me as a panelist in this workshop webinar. And I would say 2024 was a great learning lesson, and we'll go back to how a finance bill is prepared in Kenya, because it's a whole budgeting process that is done. And this is very well clearly laid out in law, from the point where the guidelines are developed. The guidelines are normally released by the National Treasury, and once the guidelines have been done, they will call the first round of public participation. That selected people come in and say, from those guidelines, this is how we expect the budget of the next financial year to be. Like now, for instance, the budget for this year was done last year. The budget speech was done last week, sorry. And already the process is starting for the next budget. It will come within 1-2 months. There will be the guidelines for the next budget, the first level of public participation. And then institutions of government are invited for sector working groups. And with that, I would say the sector working group case, Competition Authority of Kenya belongs to the public administration, public investment administration working group, where we participate actively. So you'd find for CAK, in the budget making process, they do not only participate at the point of where we have the public hearing, but also we start from the initial stages of the development. And these would come in 2 folds. The first fold is, first of all, CAK requires resources from government for its operations, and therefore it will be presenting its proposals on its intended activities through that process. So within the sector, we present our case so that we see what resources can be made available for the authority based on the activities and the strategic plan. The next frontier is on the proposals that have been sent in. So the CAK would look at the budget, the proposals that are being sent in, and check what are issues that can easily affect competition in markets, and therefore give more of an advisory role.
Yeah.
And this is espoused in our act, that we have a role to give advice to government. And this would normally happen through our parent ministry, which is National Treasury.
Correct.
And for this, we are a bit lucky that CAK is part of National Treasury, which actually ultimately develops the budget for the country.
Yes.
So with this, I would say CAK is directly involved in the budget preparation. And for last year, if you're to do a proper diagnosis on what went wrong, and this was expounded by the president, is in terms of how well was the public made aware of what's going on with the finance bill. Yeah. And you remember this was coming at a juncture where Kenya was supposed to repay back part of a big debt of Eurobond.
Correct.
And government was constrained to try and get as much resources as possible. On the next context, you're also looking at resources to ensure that there's development in the country.
Yeah.
So the proposals, I would say they didn't just land on one day that we have proposals to hike taxes. These are proposals that have been developed across a period of time. And when they came in now, the public participation, I would say because of awareness and availability of this information, there's certain groups of people would feel like, look, we do not also, this budget does not really relate to us and that does not speak to us. And ultimately, it comes to the point where you find also there was misinformation. We also have to be alive to that fact that some of the things that were raised were not the correct things that were being raised. And for instance, you have mentioned the issue of things like diapers and everything. Yeah. And if you look at an accountant perspective, they would ask, was it intended to increase price or not increase price at the end? Because either you're moving it from zero exemption to it not being zero rated, or you're moving it from exemption. So it's the matter of semantics and the words and how the conversations were picked. So there was participation from the CAK. And for instance, I would give an example in terms of some of the duties and levies that had been proposed, that CAK had given advisory and said, some of these levies, and especially in construction industry, as we are trying to promote local investors in that industry, it would also affect competition because import has been a source of competition. And for instance, in cement, clinker, there's local manufacturing, and also there's manufacturing. There are people who are bringing in clinker from outside to just grind and make cement. So we were trying to bring that balance, is that you don't raise the duty so high such that you kill off the imports, which have also helped the industry, which is, I would say in Africa, we are one of the most booming industries in terms of construction, as we are doing affordable housing and also construction of roads. So in fact, there are direct interventions CAK would make, and also in terms of now ultimately participation at the end, where CAK would go before the parliamentary committee together as part of the institutions that are under the National Treasury. So they would go to make their case for the budget and say, these are some of the measures we want to put in place. And if also we have seen in instances where, like in the past, where we want to make certain amendments to our act, that the finance bill is used as part of that whole combination to make quick, small amendments. Like one I would give in the past was in the terms of review of thresholds and creating the leeway for there to be thresholds, and also elimination of double notification with COMESA to create those rules, that the authority took advantage of that finance bill by then to bring those changes that had direct impact on the economy. So it's a very, CAK participation is there. But what I would say, and as expounded in President, that went wrong is more of how did the information go out, and also how are both parties willing to listen, that these are the challenges we are facing, but also from a government perspective, we have certain obligations that we must meet, and how do we meet those obligations?
Exactly. Yes, it is not necessarily so simplistic. I fully appreciate that. Thanks very much, Raphael. I would love to ask a couple of questions, but I'm going to leave that to the end. We have a couple of insights to get. Let's turn to Nomathemba in relation to the remedies that were imposed by the Botswana CCA in the recent past. And what struck me there was the requirement for the merging parties to replace current suppliers with brand new entrants in some instances, like in the Sapphire merger. The requirements for merging parties to divest numerous service stations to new entrants, again, in the Engine merger. And the requirement for merging parties in the Engine merger not to supply fuel to the dealerships, limiting the established firm's customer base and limiting the new entrants' source of supply. And I think, as I mentioned in the introduction to the entire conference, is the obligation that we have as competition regulators to first do no harm insofar as the proper functioning of the market is concerned. because when a market or when a supply chain is being harmed, an entire value chain can disintegrate, and then SMEs are also affected. It appears just from as an outsider that the above conditions contain numerous risks in terms of the functioning of a market. Because if there's a new entrant in a market, then you basically put a target on its back. Everybody knows this is a new entrant. We are going to try to exploit to some extent its ignorance in relation to market dynamics. The risk of new entrants not really performing at a sufficiently efficient or a reliable level. The risk of new entrants not having access to a strong supplier, in this instance, making them also a little bit weaker. And also the risk of weakening the merged entity, because now they can also not supply to a particular customer base. So while the new supply chain may look on the face of it quite competitive, my question is, didn't we significantly weaken the environment within which all the players must compete, and that in a very important supply chain? So, Nomathemba, can you please take us through the considerations of the Botswana Competition Authority in relation to the imposition of the conditions, especially requiring new entrants, and many of them to enter a supply chain? Thanks.
Thank you very much, Odie, for those very interesting questions. I think I'll start with the engine transaction. The engine transaction happened during a time where there was major transformation happening in Botswana's fuel industry.
Yes.
It was decided, I think it was around 2018, that government wanted to play a major role in the importation of fuel, right? There was a proposal done around about 2018, which was not immediately adopted, but what was ultimately adopted was that Botswana Oil, which is a state-owned government fuel company, would import 90%, right, of the country's fuel requirements, and therefore leave 90% to be imported by citizen-owned companies. So when this merger happened, these developments had also just, be taken off. So it was very important that as we considered the transaction, we were alive and sensitive to, this major transformation that was happening in and around us. Now, the decision to divest, I think we need to understand why the Competition Authority took that route in the first place, right? It was very clear that throughout the fuel value chain, the only segment of the value chain where we found there to be potential substantial lessening of competition post-merger would be the retail segment of the value chain, right? Not the bulk storage segment, not the import storage segment, but the problems that we foresaw were in the retail segment of the value chain, so the supply to retailers. I have a very interesting point to note there is that these IOCs, so Engen, the merging parties, Engen and Vitol, which is trading through Shell, as well as all the other IOCs in the land, right? The model is that most of them do not actually operate. Actually, none of them operate in the retail segment because this is a reserved segment. So the Botswana government has reserved this particular segment to citizens. And this has been so for quite a number of years now. So when we imposed this divestiture condition, we knew, first of all, that the uptake would be from these existing dealers who already have the experience, right? They've been dealing with Engen and Shell. So the only change really that you are bringing about is that you can no longer deal with Engen and Shell, but you can look within the market to see which other IOCs or even citizen-owned companies such as Petro Hyper and Tswana Fuel to supply you. Most importantly, though, remember now there is this overarching supplier in the form of government, right? We wouldn't ordinarily worry about supply because that is what Botswana Oil has now stepped in to do. They've stepped in to become the country's sole supplier. Of course, there are risks associated with that because, in essence, the government has created a monopoly in the supply of fuel. But that's a discussion for another day.
Exactly.
The point is that we had the confidence to say divest to existing CODOs, the company-owned, dealer-operated sites, because we are sure that there's security of supply. And in any case, there are enough IOCs in the land to supply these entrants. We didn't anticipate that there would be completely new entrants in any case. But if there were new entrants, that had never, for example, participated in this market, it would obviously be up to Engine or the merging parties to make sure that they've got the right set of skills or whatever it takes for them to operate efficiently at that level.
Right, because it were divestitures.
Yes, it was a divestiture of 40 service stations.
Yes.
The market share calculation, post-merger market share calculation, was in excess of 70% at that level. So we had no other choice but to dilute that concentration.
That's right.
And it's so interesting. It's really interesting how we're able to use public interest in this case to remedy this issue of concentration, which I think is quite a unique position that we found ourselves in. But I think it's also important. I'm not sure if you're aware of this, Odie, but the merger did not go through. It fell through. It has been abandoned. And as of today, we await further instruction from the merging parties. So the divestiture hasn't, in fact, been implemented.
That's very interesting. And Nomathemba, did they indicate the reason for not going through?
We have our suspicions, but we don't dwell on suspicions. We would dwell very much on what we are informed by the merging parties. And according to the merging parties, we are not the only country where this merger has not gone through as initially planned. Apparently in Mauritius, it did not go through as initially planned, where it would be a 74% acquisition by Engine. What they've informed us to date is that they could not go through because the merger couldn't go through because they were protecting. Engine is a listed company, so they were protecting minority shareholder rights.
That's very interesting. Thank you so much, Noma. Thank you for highlighting those nuances. I'm going to move to Ahmore, and we are going to discuss the HDP ownership conditions. I think it's about 2 years ago, Ahmore, that you wrote a very interesting article about the implications of a particular High Court decision for the Commission's practice of imposing ownership conditions, and I don't think that has ever been properly ventilated. So I thought let's have a very good discussion about that. The applicant was the Minerals Council of South Africa, and they successfully argued in the High Court that the mining charter did not constitute law. So many of the targets set out in the charter could not be enforced, including certain ownership targets and targets pertaining to HDP procurement and supplier and enterprise development targets. So Ahmore, can you give us a little bit of more information on this case and indicate whether there can be said that there is a correlation between that case and the practice of the Commission of enforcing the public interest guidelines, which one could argue is not law. But I leave that to you to explain that to us and to contextualize that and to indicate whether there may be a correlation.
No, thank you, Wiri, and thank you to everyone attending the conference. Now, this matter goes back to 2021, which was quite a number of years, but I think it's a very insightful matter. What we need to remind the audience about is that in allocating and granting a mining right under the South African Minerals and Petroleum Resource Development legislation, the government or this mining right is granted on the basis that there will be a 26% Black empowerment shareholding in terms of the right and the mining right that is allocated. Now, what happened is that the Mineral Council approached the courts post the publication of a mining charter. The mining charter notably goes back to 2018. But that mining charter specifically had in it very, may I call it, draconian requirements around Black economic empowerment and then procurement rights. And the parties approached the courts to say and to ask the question and raise the issues around whether a charter actually constitutes law or whether it constitutes policy on the one hand. And other than that, the question around re-empowerment and procurement, raising and expecting certain procurement undertakings. And I think listening to the audience this afternoon, these procurement undertakings have been raised on a number of occasions, Zimbabwe, and then now in terms of Botswana as well. So looking at that, the courts had to consider these issues in detail and opine as to, does the charter, to what extent it can require the re-empowerment once a HDP shareholder sold off its shareholding. And I think that goes back, Wiri, to an age-old debate as to, are you locking in HDP investors? What if they wish to exit to realize the value of their investment? And it all goes back to that. But let's just try and break it up logically. In terms of policy and law, the court said a charter is not law. The empowering provisions in terms of the minerals legislation does not empower the minister to make law. Now, if we compare that or compared to the competition legislation, the Competition Act in South Africa is very clear in Section 79, where it states that the Commission can issue guidelines. But these guidelines constitutes policy, the policy that will be applied by the Competition Commission. It's not law. And I think the Competition Act in South Africa was drafted very well in that regard to clearly indicate where the guidelines issued by the competition authorities fit in, that these are mere guidelines indicating their policy, the policy direction and the policy they wish to implement. But going further, if we consider the guidelines, and I'm specifically referring to HDP ownership, I think there's a lot to debate on. And in South Africa, in the South African society, currently there are a lot of reasons to debate it, also in light of the Electronic Communications and Transactions Act requirements around Black ownership in entities. But the first point I want to raise, and it's an old case, also it goes back to 2021, and that's the Bright Minerals matter that our competition authorities dealt with. And what happened in that instance was that there was a workers' trust. And prior to entering into the transactions, the worker trust sold off their shareholding, and it was just round about below 7% that they sold off. The Commission then assessed that transaction as if the Black ownership percentage never existed, and they concluded the transaction. Now, why I raised that is that's the point. Are we locking in Black shareholders, or are we allowing them to realize the value out of the investment? Going back to the guidelines, if we consider that, if we consider the guidelines, they are very strict policy statements, or very strong policy statements, and I think Wiri will express his view on it on my statement just to follow now. And I'm saying strong policy statements in that the Competition Commission in the guidelines indicate specific shareholding percentages for employment share schemes and then for shareholding, Black shareholding and companies. And I want to focus on that Black shareholding because that's for me where this once empowered, always empowered argument actually would apply in terms of a Competition Commission process. To what extent will we then argue from a competition law point of view that as in the mining charter instance, where the argument was and the effect of the judgment was that the holders of the license, remember they need to hold it, they have a 26% Black shareholding at all times. And the court said, But the holders of that license can continue as if they still hold the 26% where the black shareholders decided to exit in the specific organization. Now, I don't want to hog the floor, but may I quickly say this? This is a very important point because we as practitioners often get asked the question, but does the Commission realize the cost implication on entities? And that's a microeconomic question, but more from a macroeconomic perspective, whether the Commission realized the benefits to the broader economy that a transaction actually brings to the fore. And these things need to be considered. So my humble view is that if we consider the once empowered, always empowered principle, especially if it comes on the back of a loan being granted without interest and immediate dividend flow to shareholders, one would be required to seriously consider the once empowered, always empowered principle in the South African context.
Thanks very much, Ahmore. Wiri, it would be great to hear your thoughts as well, whether you think there's a correlation and whether insights should be drawn from the Minerals Council's case, especially because the public interest guidelines are not law, but a mere guideline. And I'd also like to hear your views on the issue of once empowered, always empowered. Specifically in the context of case law that the tribunal has issued in the past, which the Commission does not adhere to for purposes of its public interest guidelines, but it's there nevertheless. So if you can just share your thoughts on this whole issue of once empowered, always empowered. Thanks, Wiri.
Thank you, Odie, and greetings once again to the fellow panelists, and appreciate the opportunity to participate on this platform, because these platforms are very important, I think, to foster consensus and cooperation, not only amongst fellow regulators, but also amongst practitioners, and to have these debates and not shy away from them, even where they sometimes touch on sore points or issues that are considered for various reasons to be controversial. But I think my point of departure is that the Commission and its representatives' primary function, amongst others, is to promote awareness of the Act. So that's what I'm intending to do on this platform, although I'm doing so, of course, in my personal capacity, and nothing that I'm saying is the Commission's formal position. But the once empowered, always empowered, I think it must be seen in the correct context. That was a High Court decision, which of course is not, as we understand, binding on us or our processes. It may, of course, inform approaches in certain respects, but I think the Competition Appeal Court has been quite clear in previous cases in saying that one must be very careful when looking at precedent, maybe from other forums or even international jurisprudence for that matter. But I think in the interest of time, I think I will cut to the chase and say that our approach to Section 12A3E, because this is what this is about, is not informed by a one-size-fits-all. And I think our guidelines are quite clear in saying that, first of all, they are guidelines. They're not binding on us or everyone else, or anyone else for that matter. But we will apply a case-by-case approach, because not all mergers are the same. And why is that important? That is important because we do take into account the circumstances of each merging party when deciding whether or not interventions under Section 12A3E are required. So I think it's important to dispel the notion that we impose remedies, because and I've been integrally involved in the guidelines and their application from inception. I cannot recall any transaction where we've imposed any conditions pertaining to 12A3E or alternatives in any merger. You've mentioned the Commission not following tribunal precedent. I think there we also have to be a bit clear in the interest of the audience, because which precedent are you referring to? We have said in our guidelines that we have taken a view, and it's an interpretive view, on what Section 12A3E means. I was involved in the very first case that was considered by the tribunal, that is Simba Pioneer. I think Stephen mentioned it earlier. And from that date to present, there's not been one single decision of the tribunal or of the Competition Appeal Court or of the Constitutional Court that has said it is wrong to interpret Section 12A3E as a positive obligation. Now, oftentimes, the EPIROC decision is cited as the locus classicus for saying, well, this is why there's no positive obligation. I encourage everyone on this panel, read that decision again. It doesn't say there that there's no positive obligation. In fact, what the court, the tribunal, in fact, did in that matter was to interrogate the applicability of Section 12A3 and say the parties have tendered a remedy that promotes ownership, but it's not sufficient to address the dilution. That is why you don't stop there and say it's all or nothing ownership. You must look at other public interests, and it's a holistic assessment. And frankly, what the tribunal said in that case was not new, because even case law, which is cited in that same case predating the amendment, say that it's a holistic assessment. I don't think the commission or the tribunal have ever said that the assessment starts and ends with 12A3E. And if you don't do anything to promote ownership, whether it's an ESOP or HDP transaction, that is the end of the assessment. That is certainly, if there are cases like that, I would encourage anyone to please highlight them, but certainly none that I'm aware of. So that is quite important to understand. Now, when we say case-by-case assessment, that is particularly important given the nascent level of the jurisprudence surrounding the amendment pertaining to Section 12A3E. And I think many practitioners will highlight that we do apply a case-by-case assessment. There's many instances where parties have said to us, for example, we have previously done an HDP transaction. This transaction is about those HDPs realizing that investment. That has been allowed. I can give you case references like the Rolfies case. You can look at that. That's an intermediate merger. You can look at Bidvest Synerlytic, large merger, significant dilution from 80-something% to 30%. We didn't say, oh, you have to make good the 50% dilution or else. We concluded there that this firm, the acquiring firm, is also substantially empowered. And it's not appropriate for us to impose conditions in that circumstance. That is important because, again, there have been many public statements suggesting, for example, that the exercise we engage in is about rent seeking. Now, that is a very, very perhaps misplaced exercise. The fact that we ask the question about whether the merger promotes or not should not be taken as a view or position that the process that we engaged in is about extracting some kind of tax. It's interesting when we engage with international peers, and I'm talking here emerging parties and regulators, and they question our approach on public interest. But when we point out examples in their jurisdiction where they do things in the name of public interest, and such public interest is not even in the statute books for competition, that is, it's applied, but the parties seem to be okay with that in that context. Here you have only 5 public interests. They're very specific. The remedies must be provided that are specific to the public interest and arise because of the merger. Why is that important? That is what the Competition Appeal Court said in Walmart, and our explanatory note sets out the precedent you've referred to, Odie. Our explanatory note to the initial draft of the public interest guidelines spells out the precedent. We go through Burger King, we go through previous cases that predate the amendments. We talk about the Competition Appeal Court decision in Walmart. We talk about EPIROC even. We talk also about the Constitutional Court decision in Mediclinic. So I think our guidelines have quite extensively dealt with the jurisprudential basis, if you like, for our approach. And I think I will just, in the interest of time, stop here and say that one of the things I learned as a young practitioner from a renowned, perhaps the father of competition regulation in Africa, Mr. George Mpimile, was that merger regulation should not be viewed as an offense, like it's a cartel. When parties are before you, you are there to try and punish them for merging. That's not what we do. We have many examples, German companies, for example, who come and say, listen, this merger is about this. We cannot provide this remedy for this and this reason, and we've taken those into account. And if we were to provide you with our statistics, which I think are published there on our website, if you look at our quarterly reports, you will notice that although there has been an increase in the number of conditional approvals, that is not as stark as most people consider them to be. And in fact, when we're talking specifically, because I think your theme here is about foreign direct investment, many international transactions are approved on an unconditional basis. I'll stop there. Thank you.
Right. Thanks very much, Wiri. Thank you for your views. The case, the Shell TIPCO case, was that also considered for purposes of the public interest guidelines?
It was. And I think the Shell TIPCO case, in our view, first of all, it predates the amendments, right? That's not to say that it's irrelevant, because I think the situation is actually what transpired in Burger King many years later.
Yeah, that's right.
We consider that it is not, and this is through the application of the cases, and we can go through them if you'd like. We don't consider, as I said, that a merger should penalize HDPs who want to exit or realize their investments, because that would be self-defeating, right? Because how do you then participate in the economy when you're now locked in? They say, no, you must stay there. Yeah, yes. You want to realize your investment so you can invest elsewhere, and we say, no, you must, that's your sentence, your jail sentence, you must stay there or else.
Exactly.
That, I think, and it's good you've mentioned Shell TIPCO, because there aren't very many other instances, except for, of course, where there's extenuating circumstances, but certainly it is not a prerequisite in our application of 12A3E that even if there's a dilution, that must be addressed in whole. Because what EPIROC has done is pretty much what we do in our application. And in many instances, it's not the norm that we end up imposing conditions because we've not reached an amicable way forward with merging parties. But I think I emphasize again that it's a case-by-case analysis, and it's not all or nothing. One size doesn't fit all. We have to look at the circumstances of each case and the merging parties, and then consider appropriate remedies in the circumstances.
And Wiri, do you have the approach that where there is not an HDP or ownership, how can I say, if there's a lessening of 20% HDP ownership and it cannot be made up, that positive obligation then spills over to the rest of the public interest factors? In other words, that there must then be other types of things that must then be put on the table. In other words, you're basically removing the requirement to add a HDP shareholder, but now you have to incur costs within the supply chain. That is basically what we see. Yeah, and is that fair?
Yes.
Is that fair? Because
I think yeah, please carry on.
Okay, because that positive obligation then spills over to factors that do not have the positive obligation.
Well, I think that that approach must be characterized appropriately. So I think what we have done is most cases that end up with alternative conditions, and I think there we must be very clear that even that follows the case law cited in EPIROC, is that where you cannot remedy or it's not considered inappropriate for whatever reason, you must look elsewhere. We do find ourselves in situations where we typically consider equally weighty alternative remedies where neither party has any HDP ownership or worker ownership. Yeah. Those are, in my experience, typically the more difficult cases to deal with. And there are many firms, contrary to popular belief, who have quite substantial empowerment credentials, either at the primary and target firm perspective. And we don't only look at the primary acquiring firm, we even look throughout the group as well. So usually you find some subsidiary somewhere has got some. We take that into account because your conduct tells us whether or not you are buying into the transformation narrative. And we do consider that. I think we even consider not only ownership, but other aspects as well. So where there is no ownership, your track record of procurement is taken into account. And typically you end up with remedies where those parties in those mergers aren't doing anything. Those are the cases where you can argue that there is a need for intervention. And that is what our experience is. I think most cases, either there is ownership in the parties or they're already doing some significant contributions, and we do take those into account. Just the other day, the Omnicon IPG International advertising merger, both parties are present in South Africa. They comply with BBBE sector codes. All of those things were taken into account.
Yes, right. Thanks very much, Wiri. Thanks for your contributions. Noma, if I can come back to you, what has been your experience in relation to the ownership conditions, or let's call it citizen empowerment conditions? I'm mindful that lately there's been a merger where that there's also been conditions imposed in terms of which citizen empowerment companies who had a minority share in some of the target firms had to be empowered. Can you please just take us through that?
Thanks again, Odie. I think a lot of the work that we do that is centered around citizen empowerment really rests upon policy, right? The government of Botswana prioritizes citizen empowerment as one of its national strategies. And this is something that they have been pushing quite vehemently over the past years. We've seen this actually be put into law. There's a citizen empowerment law that has come into place. But from a competition point of view, our Section 52, which speaks to public interest, does specifically speak to the need to empower citizens where we can through the transactions that we are tasked with. The example that you've just cited of the Pick and Pay NTS is an interesting one because the citizens themselves were not directly involved in the merger. However, they were indirectly involved in the merger in that the target enterprise, NTS, co-owned certain franchise stores, right, at 60%, and the minority shareholders had a 40% shareholding. So this was brought to our attention, obviously, by the minority shareholders when they learned of the Pick and Pay NTS transaction, and that really just sparked a conversation between ourselves and the minority shareholders as well as the merging parties. Of course, you'd expect there to be a little bit of resistance there, but thankfully there is a shareholders agreement which gave the minorities first right of refusal, and that's essentially what they then invoked in this case. The complexity with such transactions is that although as the competition authority, we would, always want to protect, in a way, minorities, is that there are limitations to how far we can protect them. In this particular instance, it became very clear to us and Pick and Pay. Remember, Pick and Pay now wants to come in and take over its franchises across the country. So they have a set model, they have a set strategy, and they have to be intercepted by these minority shareholders who have come to the rescue, who have come to the competition authority to intervene on their behalf. So you can imagine, the position that we found ourselves in.
That's interesting.
So we had very, very interesting and lengthy conversations with the merging parties. However, Odie, it was very difficult for us to impose a condition that would protect the minority shareholders. So in the decision, although we did have, track record of conversations that we had with the merging parties, they did come, to an agreement with the minority shareholders that they would obviously undertake a thorough assessment of their ability, of the minority shareholders' ability to run the franchises under Pick and Pay. And in the end, only one of the franchisees was successful. The other two could not go ahead, but the comfort that we draw is that they were given a chance, they were given an opportunity, and it was by their own admission that they could not, go ahead with the transaction. So where we are now is that we are looking at the one franchise store, which hopefully will be able to progress with the transaction. And the expectation is that once the shareholders' agreement has been finalized, they will notify the transaction to the competition authority.
Right. That's very interesting. Thanks.
I might add to that debate, please. If we think about what Noma just stated, it's actually very much in line with the Mediclinic decision from a South African perspective, where the tribunal clearly stated it's about realizable imperatives for national economy. And that's what Wiri also speaks to. So what is realizable from a national point of view? And if we think about the public interest, that it definitely concerns people. At the end of the day, that's what we need to think about. And what I hear Noma stating, and also Wiri, it comes back to that point. There's no, it's not a cookie cutter approach, like I would like to say. You need to look at the specific circumstances, but there's a specific imperative that informs how we deal with these issues.
Thanks.
Absolutely.
Yes, thanks very much, Ahmore, for that as well. We are running a little bit out of time. May I suggest that everyone, starting with Calistar, just give us your final thoughts, the one thing that you'd like everybody to remember, based on the contributions that you made or something that you've heard from any of the other panelists. Thanks, Calistar.
Thank you, Odie, for the opportunity, and I also want to recognize the various contributions from the panelists here present, and I'm sure that as Commission regulators, we will always continue to learn through these platforms. And from my perspective, I think the issue of the consideration of public interest is really central to competition assessment, because at the end of the day, any policy, any government policy is there to serve the public. And I would like to just encourage and all of us to consider and deepen our analysis in competition assessment, to also go beyond the competition aspects only, and also recognize the importance of public interest consideration in major regulation. Thank you very much, Odie.
Thank you, Calistar. Right, Raphael, anything from your side?
Thank you, and to appreciate the panel. And this also serves as a good chance for us to share experience and also learn from peers in the field. And my closing remarks will be that public interest should not be seen as something that stops transactions from happening. And when parties cannot agree to the positions of competition regulators, it doesn't mean that the competition regulators are looking at stopping the transaction from going through. And the broader perspective is every agency that is looking at public interest, first of all, assess the transaction in terms of competition. And what does competition do? That you look at the factors that public interests are looking like, for instance, in Kenya, is that they are an outcome of what competition will bring in. Companies growing, SMEs being affected, employment, all those are outcomes of competition in the market. So essentially, there is nothing that we are separated from that. And also gives the competition agencies an opportunity to address the bigger overall agenda of any policy, economic policy in a country or in a region. So the public interest considerations are not per se so separate from competition. And when parties, because the biggest problem we have seen is that parties are not willing to give in full information on public interest. And the same challenge that is going on when you're coming out competition assessment. Markets are no longer based on price only and the likes. So the same challenge that public interest has always faced, the competition assessment is now also experiencing the same challenges. Therefore, there's a need of there being a clear understanding that competition regulators, and this was well put by Wiri, that they are not there to stop or make transactions not happen. There are a lot of good things come from merger regulation, public interest being a key component of that. Thanks.
Thanks very much, Raphael. And I must say, I'm also quite impressed by Zambia. The Zambia Competition and Consumer Protection Authority, they're actually quite outspoken in terms of their decisions that this merger is a positive because it constitutes investment and it will lead to employment later down the line. And that is basically one of the habitual phrases that I see in their decisions. So it is good to see that sensitivity to that. Thank you so much. Wiri, something, a last consideration from your side?
Thank you, Odie. I think what I would say as a parting shot is that the role of competition authorities insofar as merger regulation is concerned, I think must be viewed not so much as only being about promoting foreign direct investment. I say so for a number of reasons. So we should not, or we ought not to be distinguishing between foreign investors and local investors. We should just be interested in investors because we're there to regulate, as our act says, all economic activity within or having effect within South Africa. And we say so in our guidelines that the idea that, foreign mergers don't have to do anything. There's still mergers having an impact in South Africa. And that would be very unfair on local firms that they don't, foreign firms are treated differently from local firms. Local firms have to incur conditions or what have you. Foreign firms don't have to. So I think that must be the correct point of departure. Secondly, our role as competition regulators is to promote that awareness and legal certainty. That is what our role is. When you have a system that is predictable, that is certain, that is what business likes. That is what is good for business. And business benefits all of us because that's how you grow the economy. And a growing economy tends to be a competitive one. I'll pause there. Thank you.
Thanks very much, Wiri. Ahmore, your last thoughts.
My link on to what Wiri just said, and he actually ended at the macroeconomic impact of a microeconomic competition law assessment. And I think that is absolutely vital, Wiri. As competition practitioners, we work in a microeconomic cosmos where we need to think about the appropriateness and the proportionality of conditions being imposed on an entity, and then in line with Mediclinic, the beneficiaries of these conditions. But at the end of the day, we function within a macroeconomy where if we don't grow an economy, we don't grow employment. And in fact, therefore, we need to look at the value chain and the impact on the macroeconomic value chain if we think about public interest and conditions.
Thanks very much, Ahmore. Basically, we would have to think about how do we translate microeconomic intervention into macroeconomic prosperity. That's the translation, I think, where there's a lot of work still being done just from a theoretical perspective. And Stephen, your last input on this panel.
Let me just go off silent. If I can just add on to what Wiri and Ahmore said, for any investor, it is encouraging if there is a more holistic approach towards considering mergers. Whether or not investors like it or not, public interest considerations will always form part of an assessment of the Competition Commission, but it should not be the stop in the transaction there. Like Wiri said, it's not a one-size-fits-all. There are many other avenues you can approach towards ticking the box of public interest considerations. And I think that is all. That is as long as we evolve as a country in terms of competition authority enforcement and keep on developing how we apply all these principles and rules and policies in order to have a balance between transformation goals versus growing the economy, then I think we have a good future ahead.
Right. Thank you so much, all of our speakers, helping us out on many different public interest conditions and concepts. I really appreciate your valuable contributions and all the hard work that went into this.